All right. Hi, everyone. Hopefully you're well. I'm here with the ladies, Adele and Fiona from Haven Legal Co. Sorry. And my name's John Casher from the AFA Group Wealth. We're here today to talk about essentially everything wills. We'll go through a few common questions that we kind of get. We'll go through a bit of what the ladies actually do and how we work with them. And please feel free, if you've got any questions or any comments, just leave them below and I'll be happy to answer them, and I'm sure the ladies will be happy to answer them as well. Okay, so maybe over to you, Adele. Do you just want to let us know a little bit about the business and a little bit about you ladies?
Well, Fiona and I joined forces earlier this year and started Haven Legal Co. together. So usually we work in Coburg, but we're all at home, just like the rest of Victoria. So working from home at the moment. So what we generally do when we're in the office is we operate a couple of different practice areas. So we have wills and deceased estates, conveyancing, and family law are our main areas. And we're, I suppose, not just because of COVID, we are trying to operate as largely an online firm. So pretty much everything that you need to do with a solicitor at our firm can be done online. So sort of marketing as much as we can to busy families who don't have time to actually come out and meet a solicitor in person.
Well, I guess that's pretty cool because we do the same thing. We're trying to accommodate the best we can. If we look at the traditional way of going to see a lawyer or going to see a financial advisor, it's booking a time after work usually, or we'll try and get some time off work, drive out. And I think there is a positive spin to COVID. Most people are being forced to use online, and it's really good to hear that from a legal perspective. You guys are doing that.
Yeah, absolutely.
Fiona, do you want us to let us know a little bit about yourself, maybe, and a little bit about the background? Adele's filled us in regards to the business. Let us know a little bit about yourself. Like how long you've been doing this stuff for? Has it been 2 days, or has it been a little bit longer than that?
Me personally, as you know, John, my background was actually in the financial market. So for many years, I did work as a derivatives dealer for a fund manager. And then through the global financial crisis, the last time we had a real shakedown, I found myself, wanting to change things up. And so I've gone and studied and got my law degree. And so since then, yes, we've worked predominantly in those practice areas, which is wills and estates, family law and conveyancing. Meeting Adele a few years ago, finding a kindred spirit has been wonderful. So we are really focused on, listening to people and providing them with really good and sound legal advice so that they can make informed decisions and choices. The thing that we've also done for a number of years, unlike traditional practices, is that we have been flexible with our conference times. We've been doing video conferencing for a number of years. We are able to do conferences at night once the kids are in bed, because what we find for most people is that the opportunity for somebody and their partner to take time out of their work day in order to meet with a solicitor is a challenge that is just too much. And so for us, it's important that people do have their wills and their estate plans. So we try and fit in with their day and their commitments to ensure that they still have access to advice, are able to get an understanding of what their choices mean for them and their families. And then have access to those documents so that they're able to have that peace of mind going forward.
That's awesome, and thanks for filling us in. And obviously, you can see, both ladies have a long relationship in the legal space and also in the finance space. And obviously, that's works really well with me because, I'm an advisor that takes the estate planning journey for our clients very seriously, and usually in most cases it's the last thing that a financial advisor looks at. In our case, it's actually the first thing that we look at, because we usually, when speaking to clients, there's the financial goals are usually for not only them, but for their kids, their grandkids, and it's the legacy that they leave. So it's very important that we work with people of the same ethos and understand the importance that this plays in their lives. So I've put together a couple of questions that maybe we can kind of run through that I hear a little bit, but as well too a couple that I've put together that might be able to help the people who are viewing this. So let's start with maybe when is the right time. I find there's a big misconception. It's like, I'll wait until I have kids, or I'll wait until I get married, or I'll wait until I get a divorce. I'll wait. There's always a better time to do it. So let's maybe talk about when's the best time. Like if you were at a barbecue and you were speaking to your friend and they said to you, when's the best time? Adele, when is the best time to get started in your estate planning documentation and plan?
I smile because you're right. We hear it all the time. People will be buying property, or, they have just had a child and they sort of, but we're going to have another child, so we might wait until we have this next one, And we always say, the second you own something, you need a will. Mm-hmm. So, I mean, once you own your first car, and people think, we're so young, but really, I mean, anything can happen to you at any time. It should never be we've got to wait for this. And I'll let Fiona deal with what happens if you die and you don't have a will, because that's a minefield all on its own, and you can end up with family members that are inheriting your assets really without your consent, of course, because you wouldn't have done your will, and you probably wouldn't want it to go to some of the people that the legislation says it has to go to. So we do generally say, as soon as you own anything, you should do a will. Go on.
So if, for example, let's say I'm a 21-year-old, I've saved up a little bit, I'm saving for a deposit of a house, I've got no kids, got no girlfriend, it's just me, still living with mum and dad. Yeah?
Yep.
When I see that scenario, the importance is probably not on the highest level for this individual.
Of course.
Yeah?
Yep. Mm-hmm.
But the will for that person is maybe one element, and there's other elements in that person's life that maybe they're not viewing it. And obviously having you ladies here, and I'm more talking about, for example, as a 21-year-old male, if you looked at the statistics of things that can happen to that individual, it's actually up the higher end.
Yes.
And, who makes that decision for that person if he can't make it for himself is what I'm trying to allude to. Yeah. And I think that a lot of young people at that stage, and even in the next stage, which is the person we say the girlfriend, or in a relationship.
Yeah.
And then there's that, oh, well, you know what? I'm the girlfriend or I'm the boyfriend. No, I'm making decisions for him. I'm making decisions for her. No, the mum and dad come in. Then it might be the brother or the sister. And then there's all these people. So wills and power of attorneys, obviously I'm alluding to it, but, a little bit more from maybe you guys, do you see this as common problems? And do you see this as issues that especially the younger generation, I think, just are totally oblivious to? Do they need to do something about this?
Look, absolutely. I mean, all of those points that you've raised, John, are actually really critical, because depending on who comes and goes within your life, will certainly impact on who you want to have as the decision makers, either if you lose capacity or in the event that you pass away, what happens to your assets. And even as a young 21-year-old male who may have some superannuation, they may have some insurance, even if it's just the default insurance, it's still important for them to know that when they pass away, who are the people that are going to benefit from their estate? What assets do actually go into their estate and what doesn't? What are the tax implications in the event that they pass away with potentially some of their assets? Yes, they might have a girlfriend. Does that girlfriend fall within the definition of a de facto spouse? Is it that that person will be able to make claims against the estate when in actual fact the 21-year-old really wanted mum and dad to be the beneficiary? So disputes are a part of what we see every day. We also hear a lot of stories about, well, my family won't be like that. But that's the reality.
That won't happen to me.
Yeah, the reality is that this isn't what we see. We certainly see that relationships break down post somebody dying simply because they feel they haven't been left with adequate provision. The legislation doesn't really deal with the complications of people's families. Are mum and dad divorced? Do we have half brothers and sisters? Do we have step siblings? So, even without a spouse to leave the assets to, perhaps their own family circumstances are complicated as well. So there's no answer. So I think the time to start a will is right now.
Yeah, and I think, yeah, and even more to that point, a proper estate plan, and I've started to use this a fair bit because I think it resonates quite well with clients, is when we're working through their journey on essentially trying to develop their life story.
Yeah.
The estate plan is recording that. It's your recording mechanism that if you can't tell someone your story or what you want to happen, make sure it's recorded down. Yeah. If you can't fulfill your own story, who plays the main role? Yeah. Who plays the lead role if you can't do it? And so people, I think, need to be aware that all this is trying to do is trying to make sure that, your story continues beyond you. Yeah. And even if you can't, play your role in your story, that the person that you want to play plays that role. And, I'm an advocate of starting as early as I can. I think there's another misconception is, well, not a misconception, but maybe a little bit of a hurdle for maybe the people that are getting into this. And I'm not talking about necessarily younger people, I'm talking about across the board is, one, it's cost. It's, I know I need to do this, but I want to make sure that my life's really complex before I do it because it's a big investment. Yeah. And obviously we know that that's a bit of a misconception. It should be kind of avoided, getting it as early as we can. But I think the other one is about changes. Yeah. And let's be honest, it's like, I want my will to last forever.
Yeah.
Yeah.
Unrealistic. Yeah. Let's be honest. That isn't unrealistic. Doesn't matter how great I've seen a will or an estate plan designed. Yeah. There's always changes that need to get done. So let's say the person goes in, gets their will as early as possible. Yeah. Gets their power of attorney set up. Gets all their documentation. How regularly would they update it? And when we're talking about like majority of changes, are they significant? Like, let's get to the grunt of it when it comes to costs. Like, what do you usually see when it comes to, Adele, what does it usually come to when it comes to a change? And what's a variation cost for these people? Like, what is that?
Okay. So, I mean, you do your will, if let's say you do your will, we'll use young 21-year-old male. So he's done his will at 21, meets his life partner at 26. And in between 21 and 26, he's accumulated some assets. The way that most solicitors will word wills is that everything that you purchase in your name, everything that stands in your name, less super, falls into your estate and is then left to who you want it to go to in your will. So if you buy or sell property, we generally prepare them so that we're not naming specific assets. If you do that, so if you leave, your Monaro to your brother or whatever, and then you sell that car and purchase a different car, then that asset actually fails as a gift. Okay. So things like that, yes, you would have to actually come back and say, well, Adele, I've now sold this vehicle. Maybe you should have worded it differently. Maybe it should have just said whatever car I own or whatever vehicle I own. So we're very careful so that people don't have to come back every time they change an asset or buy something or sell something.
And do you think that is I think that also comes from experience from the solicitor and the lawyer. And I think that, this is where there's probably even some, pushback, especially from you guys, but, even from us in regards to, DIY kind of will kit scenarios. Yeah. Where it most definitely would be in most cases, the Monaro. Yeah. Or, and as we know, and having good advice really early, spending the money for quality advice actually in the long term helps out so much. So, let's continue with the story for this person. So they're now together in a relationship. Yeah.
Yep. So we've met, new life partner, we're engaged, but we've still got mum and dad as the main beneficiaries in the will. So what we generally hear next is, we're going to wait until we get married. Now, you don't have to wait until that happens. You can actually change your will at that point in time, prior to the wedding, and you probably should. I mean, if you're making a commitment to this person, and something happened to you before you got married, or God forbid on the honeymoon, but I mean, these things do happen. You should be changing your will at that point in time. Okay. And so at that time when we change it, we would automatically put everything goes to each other, being new life partner, and we include children. Okay, so they sort of, but we haven't had them yet. Doesn't matter. The way that we word it is we include all future children. You do not need to name the kids, because a lot of people then, you get busy with life with kids and you're not going to come back for maybe 10 years. So we try and include children, maybe even grandchildren. Some people don't come back for 20 years to do their wills. And then we sort of go down the line to then mum and dad, then siblings, blah, blah, blah.
So I go do that. So I'm Barry, and I've gone and I've done my will. I'm with my life partner. And for Barry, maybe you've future-proofed this for me. Great work, ladies. I don't need to see you for 20 years. Yeah.
No,
but that's also but that's also not the reality, is it?
No, it's not. No. And so there are many things that, and certainly part of the package that you will get with us, we send you a list of scenarios, so examples that you will then have in mind. If this happens, you need to come back and talk to us and change your will. If these things happen, don't worry about it. Okay. So I suppose things that you don't need to worry about is if somebody changes their name, if they move address, if you sell or purchase real estate, because in most cases we have worded it that it just includes everything. And then I suppose other things on the flip side of when you definitely need to come back, you are separated, you're getting divorced, you've lost a child, you've started a company. Opened a family trust. I suppose anything that, when something significant really changes in your life, you can even pick up the phone, give us a call, flick an email to us and just say, hey, Adele, this happened. Do I need to speak to you? And we're not going to charge you for something like that. We will just come back and say, no, don't need to worry about it. That's fine, But yeah, certainly we do suggest every 3 to 5 years, probably worth just having a conversation with us that we don't charge if we don't do any work. We'll just have that chat and just say, nah, you don't need to, or yes, you do, and it's going to cost you this much. So,
well, you're gonna love us, because every 2 years we actually have what we call an estate planning checklist. Yeah.
Nice. Yeah.
And what we do in our firm for our clients is just check on these changes, self-employment, marital status, this, that. And we've got kind of a bit of a checklist that we go through, because we know that this gets away from people. Usually it took them hard to kind of get it done. Yeah. Let alone pick up that document.
Now try and get them to change it. Yeah.
Change it again. Now let's just use a specific example. And I'm talking about, I don't know. Hey, I want to add in a specific gift to my will. Yeah. For example. Yeah. So I want to give $100,000 or 10% of my asset to charity. Yeah. How much would that cost? Like, is it a significant difference? Like, because, let's say, a will, let's just call it $1,000 just for this exercise. Yeah. It's $1,000 to get a will. Am I having to go then spend another $1,000 to throw it in the bin again and start from fresh? How do these variations work?
Sorry, Fiona, do you want to?
Yeah, so look, I guess the fortunate thing is that you come back to the solicitor who drafted the will. We have all of the documents there, and all we're really doing is making some minor changes. The changes for us are usually around $100.
Yeah.
To just simply make those changes, send the documents back out, and arrange for them to be re-executed. Yep. So we never alter, not these days, we don't alter the old will, we don't cross things out, because that often complicates things in regards to alterations and changes. There's specific requirements around how they're signed and witnessed. You know, we have the benefit of having the documents that are easily to change or amend. Where we look to say there may be some complex issues around those changes, it might be, once again, that we've changed structures, that we've moved assets into a non-estate asset, or we're trying to equalise particular asset classes depending on tax obligations, or we might be granting a right to occupy to a person for that estate asset. So all of those types of changes that might require a consultation, just some information regarding the legalities around their decisions, then obviously those costs are taken into consideration and quote at the time. But simple changes, absolutely not. And it is vital to ensure that your will does reflect your wishes, and you do change your wishes from time to time.
And I think someone who kind of sticks on top of it will probably end up, from a cost perspective anyway, actually saving money because they're on top of it. Because the large ones where it's like, we haven't seen you guys for 20 years. Well, you might as well cut everything up because, you know,
you're doing it again. The whole thing.
The whole thing again.
100%. 20 years later, you really probably need an entire consultation in order to bring that person up to date with where the current law stands. You know, as we said, their assets have gone from being a bank account and a Monaro to being, you know, a couple of businesses, a trust. We've now got business partners, trust deeds to review, a self-managed super fund, you know, all of those assets.
And an ex-marriage probably, you know, these days that you've got to account for as well. Now, the other one as well too, and this is going a little bit different. What's the view with, like, for example, same-sex marriages and stuff like that? Like, are we now at a point where, you know, same-sex marriages are viewed kind of from an estate planning perspective exactly the same as a normal traditional kind of marriage arrangement? Is it different? You know, I know we're here with marriage equality, but, you know, is there any differences in regards to that? De facto and kind of married state. Is de facto, is same-sex marriage, is marriage from a family law kind of estate planning kind of the same?
They are one in the same.
Okay, cool. That is nice and easy because, you know, you do get that, you know, where they're like, oh, I've been in a relationship, like you said before, I've been in a relationship for 18 months, or you'll have, you know, especially because it's quite new in Australia when it comes to same-sex marriages and stuff like that. It's obviously, you know, only a year or two ago. Geez, it's probably a couple more than that, you know, flying in COVID. But, you know, that was really important for me to get out and understand that.
In saying that, de facto is probably, sorry, I could see Fiona was thinking the same thing. De facto is a little bit more complicated. I mean, same-sex marriage doesn't matter. It's all the same these days, as it should have always been. And I suppose with de facto, the general rule is 2 years. So you need to have been living together in a marriage-like relationship for at least 2 years. But in saying that, that doesn't mean you're going to get everything if that person dies. It just means that you are then eligible to actually put a claim in. So
if I've been dating, let's say, a lady for 6 months.
Too bad, so sad.
Okay, because that's an interesting one as well too. You know, there's been some discussions that I've had where people sometimes think, you know, it's 6 months or 18 months. So is it 2 years?
It is 2 years, John. So under the wills legislation, you need to have been in a genuine domestic relationship for a period of 2 or more years, as at the date of death.
Yeah, and is it like one of those rules where, for example, it's like publicly known as a couple, like one of those ones?
Yeah. So how do we determine genuine domestic relationship? The relationship that has some indicators.
Yeah.
And so those indicators include things such as, well, cohabitation makes things a lot easier. Have we got any joint finances? Children sort of change that calculation altogether, and children obviously are a big indicator. What is the public nature of your relationship? Absolutely. All of those things come into play. Without a will, then you essentially, as the de facto spouse, will be required to provide evidence of your relationship. And at a time when you're grieving the loss of a partner, where you don't have a will, so you're not automatically a beneficiary, there's a lot of hoops that you have to go through in order to prove that relationship to the court. And sometimes that involves affidavits from family and friends. Sometimes you also have family members who might not have actually been on board with that relationship. And so they're going to challenge as to whether that was a genuine relationship. So wills can overcome that turmoil that you'll face in the event that a person passes, and you're now justifying who you are.
That's a good one for people to consider. You know, I think it's probably a common one that people miss.
Absolutely, yeah. Families aren't always on board with your partner and the relationship that you have, and will often challenge that relationship.
When it comes to money as well, too, as everyone knows, everything comes out the woodwork. So, so when it comes to specific instructions, this is obviously one we've touched on. So you'll have a lot of people that is like, I would imagine, I want to leave that chair to my second cousin's auntie. Yeah.
Yep.
I want to leave that, teaspoon to my uncle's dog's partner.
Not as funny as it sounds. It happens all the time.
Yeah.
That dish bowl needs to be for that anyway.
Yep.
Yeah.
Views on specific instructions. Obviously, we have brushed on them. And what do they actually mean if someone kind of puts their hand up and says no? Like, so let's say it's mum and dad. We'll make it real simple. It's mum and dad, 3 kids.
Yep.
The daughter, let's just say she gets all the jewelry.
Yep.
The son gets all the garage. And the other son gets, I don't know, whatever's in the house. Let's call it. Yeah?
Yeah.
And one of the brothers says, nah, I got the garage. There's nothing in there. I'm going to contest this.
Yep.
Yeah.
What happens?
What happens? And is it really worth? Yeah.
No, look, it's probably not. We're using that scenario. He contests. If the first thing he would do is raise it with the other beneficiaries. So he'll raise it with the other siblings. If the other siblings say, oh, look, whatever, let's just negotiate it and we'll just work it out between ourselves. Provided there are no other beneficiaries mentioned in the will, then they can do that. They can sort things out between themselves. But if, the sister that's getting all the jewelry says, no, I don't agree, then unfortunately you're left with a scenario where you then get solicitors involved. If you and all of a sudden the what was worth $1 million in the estate, that all starts to get eaten up by everyone fighting. Okay,
and this could be like really not even like say gold jewelry. We're not even talking about diamonds here. Let's be honest, it's mostly for the teaspoon that's like $3.
We've fought over less. So
and then it just. And because there's this thing, it's like, but then the lawyers can't, but they're trying to just sort out a problem between you two. So maybe alluding to this, is there some common problems that maybe people can obviously avoid? Is it specific instructions? What do you think makes an easy will?
The rule of thumb is really, if you want your instructions to be binding, then you put that in the will.
Yep.
And if your instructions are that, my family heirloom chair will go to my great aunt, second cousin, then that's binding. Your executor doesn't really have any discretion in regards to what happens to that chair. Does the estate pay to transfer that chair if the person lives, say, in Perth? And we can put instructions as to regards to costs does the estate pay the costs, or does the beneficiary pay the costs of transfer? Things such as pianos can be really costly when you're transferring those across the country. But when you say, I'm just going to leave a list, and I'm going to put that list with my will, and it just says that, my shoe collection, I'm going to allow my friends to come in and pick what they want, or, my record collection can go to my cousins as my executors determine at their discretion. All of those things are wishes. And so really it's a set of instructions that are not binding, and it's up to the executor as to what they do with those assets. So binding, we put it in the will, no discretion. Yes, if a beneficiary says, well, the tools in the garage didn't actually amount to the same value as the jewellery, it's kind of too bad.
I've heard the saying before that if you want something to really go to someone, no questions asked, you give it to them while you're alive.
Well, there's that as well.
Yeah, true.
Yeah, so if you really want them to have that chair, just send them the chair.
Yeah, that's it.
Anyway, so for people that obviously want to reach out to the ladies, you can go directly to them or come through me, and I'm happy to pass on their details to you. But I know you guys are real advocates of having like fixed prices and packages and stuff like that as well too. So can you quickly just run through me for singles and couples, just roughly what they'd be looking at to actually get their wills, say power of attorneys. And we haven't really brushed on testamentary trust, so we may bring that up in another conversation. But maybe just for the basic scenario, what are they looking at for these general documents?
Yeah. So, I mean, usually, and I say usually because at the moment we are having 50% off all of our packages, excluding testamentary trusts. But so at the moment, say for a single person who needed a will, $220 is what it is at the moment, usually obviously $440. And if you're looking as a single person for getting the package, so you'd get your will and a medical and also enduring power of attorney. At the moment it's $330, usually $660. So it's obviously a massive drop at the moment. A great time to get everything sorted. So as a couple, so couples are probably even better again, I guess. So 605 is will get you everything. So that'll get you 2 wills, it'll get both of you, your medical and enduring all sorted. The way that runs is, again, we like everything to be very streamlined. So we have an online form that you can either access yourself on the website or we can send it to you. You fill in that form, we will then contact you and book you in for a Zoom conference. And so for that, I mean, you'll get an hour and a half, whatever it is that that you need to go through all those documents. So we will actually draft everything based on your instructions online and send you that at least 24 hours before the conference. With additional questions. So we're not wasting time, I guess, in the conference sort of asking, the address of your mum or whatever. All of those things generally have been sorted out before that.
So if I'm a client and I kind of don't really know, do you guys or you ladies walk me through, the key roles, and stuff like that? Because I have found, and not from you ladies, but I have found where a client has potentially gone seeing a lawyer, they've whacked a form in front of them, filled it out, and then the estate document has kind of came exactly just what the instructions were. And when asking the client, I'm just like, was there any advice about this? And obviously I can't give legal advice, and obviously I don't, but I look at it going, do you give obviously advice, because people don't know what they don't know.
So a couple of things. The online form is actually not just who do you want as your executor. First it will say what is an executor, and it will talk you through their role, when their role starts, what they do, all those sorts of things, and then it will launch into, so who do you want this person to be? Now you do have the opportunity to actually say, I either don't understand the question, I need further information. There are other options there. And then we go through all of that in the conference anyway.
Mm-hmm.
So yes, you will get a draft, but that doesn't mean it's the be all and end all. And if you haven't given us the right information, we're going to charge more. We don't work that way. We know a lot of solicitors do, but we don't work that way. So you'll get to conference. Anything else that needs to be sorted, we'll send you away with a list of things, and we'll chase that up afterwards. So we're definitely not we don't operate that way.
Awesome.
Yeah. You will understand. We will make sure that you do.
We work through a lot of scenarios as to, what is the role of the executor? What are their responsibilities and obligations? Are they responsible for money in caring for, managing the estate funds until the children reach a certain age? What does that mean? What is their discretion? There's a lot of time spent with the client so that they do understand these key roles, so that they are confident that these roles are going to be undertaken by the people that they trust, and that those people are capable of fulfilling those roles.
Awesome. Well, ladies, thank you very, very much for today. I'm sure everyone had got a lot of value out of it. I surely did. But please, anyone, if you've got any questions, please shoot them to me, leave some comments. We'll get to them accordingly. And I'll leave the ladies' contact details in the comments below as well too. So feel free to contact them directly as well. So thank you once again, ladies, and
Thanks,
to everyone. Have a great weekend. That's okay, ladies. Have a great weekend, and everyone keep well and keep safe. Okay?
Thank you.
See ya.